Now that a criminal complaint has been filed against Atty. Lambino and Cardema for violation of Article 154 of the Revised Penal Code over the alleged fake news about a TRO issued by the Supreme Court, what exactly happens next at the prosecutor's office? How does the legal process move forward from here? That's what we're going to talk about in this video. Let's get started. Para sa storyang legal, paminaw kang fiskal. What exactly is unlawful publication under Article 154 of the Revised Penal Code? And did Lambino and Cardema really cross the line? Hey everyone, I'm Piskal J and welcome to Legal Weapon. Just yesterday, the NBA filed a criminal complaint against Attorney Raul Lambino and former National Youth Commission Chair Ronald Cardema for allegedly violating Article 154 of the Revised Penal Code. That's unlawful use of publication and unlawful utterances. The complaint stems from the claim that the Supreme Court issued a TRO to stop the arrest of former President Duterte, a statement the Supreme Court itself has denied. But what exactly is the crime about? What are its elements? And how do you prove it? Let's break it down. Article 154 is the unlawful use of means of publication and unlawful utterances. This law punishes certain forms of speech or publication that threaten public order or mislead the public. There are four punishable acts under Article 154. First is publishing false news. Second, encouraging disobedience to the law or authorities. Third, praising acts punished by law. And fourth, malicious publication of official resolutions. While I am not entirely certain whether Attorney Lambino and Mr. Cardema were specifically charged under the first act of Article 154, the publication of false news, based on the reports circulating in the media, it appears highly likely. Now that we've identified the four punishable acts under Article 154 of the Revised Penal Code, we will focus solely on the elements of the first act, as it is the most relevant in this context. For the purpose of clarity and relevance, we will not delve into the elements of the three remaining acts. Now, what are the elements of publishing false news? First, there is publication or distribution of false news. Second, the person knew it was false at the time of publication. And third, the false news may endanger public order or cause damage to the interests or credit of the state. Now that we've covered the punishable acts under Article 154 and the elements of the first act, let's move on to how the Supreme Court has interpreted these provisions. While direct convictions under Article 154 are very rare, several landmark decisions shed light on its application, particularly in the context of freedom of expression. In the case of Gonzalez versus Katigbak, his case dealt with the censorship of a film by the Board of Review. Although it didn't involve Article 154 directly, the Supreme Court made a crucial point. Freedom of speech is not absolute. It may be reasonably restricted in the interest of public order, morality, or national security. In the case of People versus Pablo, though Mayor Pablo was convicted under Article 142 of the Revised Penal Code for inciting to sedition and not Article 154, Nevertheless, the case is important because it talks when speech crosses the line into incitement, which is a key point when interpreting Article 154. We'll talk more about this case later. In Chavez versus Gonzalez, this case involved the Hello Garcia wiretap broadcast. The government threats to block the broadcasts were ruled unconstitutional. While Article 154 wasn't invoked, it shows how laws affecting media and speech must respect constitutional limits. These cases guide how courts balance speech and public order, which is exactly the tension at the heart of Article 154. Let's revisit People versus Pablo, a key case in understanding the limits of free speech in the Philippine law. While it involved Article 142 inciting to sedition, it often comes up in discussions on Article 154. Both deal with speech or publications that can disturb or challenge public order. In this case, Mayor Pablo of Macabebe, Pampanga distributed leaflets to the public. The leaflets accuse council members of corruption, abuse, and inefficiency, urging citizens to take action. But the call to action implied steps outside legal remedies. He was charged under Article 142, not Article 154, but the overlap is striking. The legal issue here is whether or not the speech given by Mayor Pablo was protected speech or whether or not it amounted to inciting to sedition. The Supreme Court affirmed Mayor Pablo's conviction. They ruled that the leaflets weren't just critical, they incited hatred and disobedience against authorities. In the said case, the Supreme Court pronounced three key legal doctrines. First, the Supreme Court said that speech that threatens public order can be restricted, urging people to act unlawfully even without malice may still be punishable. Second, back then, speech could be punished if it merely tended to incite illegal acts. And this is so different from the clear and present danger rule which we use today. And third, criticism is healthy in a democracy, but baseless accusations that provoke action are not protected. Publishing to incite disobedience or mob behavior violates the Revised Penal Code. You may ask, why this case still matters today? Why? Because even though Mayor Pablo was charged under Article 142, the case still gets this case still guides us how we interpret Article 154, especially when it comes to inciting to sedition principles, false and inflammatory publications. Today's social media posts, online rants, or public fake news could be measured against Pablo's precedent. Summary: freedom of expression has limits. When words incite disorder or defiance of authority, they may cross into criminal territory. Intent and potential effect matter. That's a vital lesson in the era of viral misinformation. However, it's important to highlight the case of People versus Pablo, which is actually a 1965 case where the Supreme Court applied the tendency doctrine. Under this doctrine, speech could be penalized not because it caused actual harm, but simply because it had the tendency to incite unrest. Even if no violence or illegal act occurred, Since then, however, the Supreme Court has moved away from this approach, favoring stricter tests. What changed? The Supreme Court has shifted from the tendency doctrine to the clear and present danger rule, inspired by U.S. law. In Brandenburg versus Ohio, the Supreme Court now demands a real imminent threat that causes serious harm before speech can be punished. So, for example, today, an influencer posts misleading, aggressive opinions online. Under the Pablo tendency doctrine, that could lead to punishment even when no violence happened. But under the Chavez or David modern cases, it is considered protected unless there's a clear and present danger. In the modern case of Chavez versus Gonzalez, a 2008 case, DOJ warned media not to air the Hello Garci tapes. They threatened legal action against press outlets. The doctrine applied clear and present danger rule. A real and immediate threat is needed before suppressing speech. The court ruled gagging the press was unconstitutional, so broadcasting of the tapes was considered a protected speech. In the case of David versus Arroyo, a 2000 case, during Proclamation 1017, protests and media were suppressed. The government invoked national emergency powers, but the court applied the clear and present danger rule again and declared parts of Proclamation 1017 unconstitutional. The Supreme Court declared mere criticism of government is not enough to silence speech. So in today's standard for conviction, the elements must be present. The publication is false. The author knew it was false. It incites disobedience, panic, or violence, and it poses a clear and present danger. You may ask, is there a clear and present danger test? Yes, there is. The Supreme Court said that speech may be limited only if there's a danger of substantive evil, like violence or rebellion. The danger is imminent. It's about to happen. The third, the speech incites or produces that danger. Fourth, there's a causal link between the words and the threat. And 5, the threat is serious, not imagined or trivial. Unless all these are proven clearly by the state, speech is protected. In short, will these words likely cause illegal action soon, not eventually? Now let's compare. So say for example, there's a crowd and the speaker riles them up saying, "These corrupt councilmen must be removed by any means." Such statement under the tendency doctrine is already considered punishable even if no one acts on it. Under the clear and present danger, that very same statement is not punishable unless people begin reacting or preparing for violence. Conclusion: tends to means possibly harm even without proof. Likely to means probably harmful soon and with real context. The test looks at intent, content, context, likelihood, and timing. Bottom line, free speech in the Philippines is now more strongly protected than ever. Now that we've covered what constitutes a violation of Article 154 of the Revised Penal Code and its elements, let's move on to the next part of the next part, which is the procedure. So what happens now that the National Bureau of Investigation, or the NBI, filed the complaint before the prosecutor's office? The case will be raffled to determine which prosecutor will handle it. Once assigned, the records are forwarded to the designated prosecutor. Given that the penalty for violation of Article 154 is only 6 months of imprisonment and or a fine of 1,000 pesos, the case is classified as one requiring summary investigation only. As such, the handling prosecutor is given only 10 days to resolve the complaint. Since this is a summary procedure, the prosecutor is not required to issue a subpoena to the respondent, unlike in cases where a full preliminary investigation is required. The resolution will be based solely on the evidence submitted by the complainant. So, if I were the respondent, I wouldn't wait around for a subpoena because it's not coming. Instead, I'd go straight to the prosecutor's office, secure a copy of the complaint, and immediately file my counter affidavit. Quick action could make all the difference. So, what are the possible outcomes? If the prosecutor finds probable cause, he will draft a resolution together with the corresponding information for the approval of the chief prosecutor. If no probable cause is found, the prosecutor will prepare a brief resolution recommending the dismissal of the complaint, also for the chief prosecutor's approval. Now that we've laid everything out, what do you think will be the outcome, especially with the clear and present danger doctrine in play? Drop your thoughts in the comment section. I'd love to hear your insights. If you found this video helpful, don't forget to like, subscribe, and leave a comment. Your support really helps this channel grow. While you're here, check out my melodic dreamscape. The perfect background music while drafting pleading affidavits or simply clearing your mind at work. Links in the description below. So this is the lo-fi music of my melodic dreamscape. And if you're driving, try playing my song The Beauty of His Time under my artist name Jon Lualhati. It's a heartfelt piece about asking God for patience and waiting for His perfect timing. It's perfect for staying calm on the road and steering clear of stress and road rage. Also, link below. So, thank you once again, and I hope this video gives you further knowledge and that my music brings you peace and clarity. Thank you. Letting life bend to your will. On the days when doubt begins and the hope seems so thin,
It's like a flickering light, and faith appears out of sight. There are times I feel the strings stumbling on the edge of pain. I question your divine plan, struggling to understand. God give me patience to fight my frustrations. Teach me how to wait and be calm in silent prayer. Infuse me with serenity amidst life's much uncertainty. Teach me, Lord, to just be still, letting life bend to your will. God give me patience to fight my frustrations. Teach me how to wait and be calm in silent prayer. Infuse me with serenity amidst life's much uncertainty. Teach me, Lord, to just be still, letting life bend to your will. Letting life bend to your